Today we're going to talk about Article 3 of the Constitution. That covers the Supreme Court and the federal courts. And we're going to talk about the power of judicial review, which is the power of courts to strike down unconstitutional laws. We're going to cover two texts, and they're really exciting and important. The first is Federalist 78, which is Alexander Hamilton's defense of the federal judiciary. And the second is the landmark Supreme Court case of Marbury versus Madison. Let's begin with the text of Article 3 of the Constitution. Section 1 says, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." So the Constitution says you have to have a Supreme Court, but Congress may, if it chooses, establish inferior courts. And then it says the judges both of the Supreme and the inferior courts shall hold their offices during good behavior. So that means they have life tenure. Then Section 2 of Article 3 says, "The judicial power shall extend to all cases in law and equity arising under this Constitution and the laws of the United States." And then it goes on to set out a limited category of other cases where the Supreme Court has jurisdiction. That means the court is allowed to or required to hear the cases. And then it says that Congress can make whatever exceptions and regulations that it likes. So the founding generation established this text, which doesn't say a lot, except that there has to be a Supreme Court, there can be inferior federal courts, and there's a certain category of jurisdiction that the Supreme Court has. But it was broadly accepted in the founding generation that this text included the power of judicial review. In other words, the power of judges to strike down unconstitutional laws, even though the text doesn't mention those words. So where did the founding generation get the idea that judges had this power? Federalist 78 gives us the answer. It's so meaningful to read Federalist 78 because it's such a clear explanation in Alexander Hamilton's immortal words about why judges have the power to strike down unconstitutional laws. First, Hamilton famously defines the judiciary as the least dangerous of the three branches. Why? The president holds the sword, he can declare war. The legislature holds the purse, it can decide whether or not to fund stuff. The judiciary, on the contrary, has no influence over either the sword or the purse, says Hamilton, no direction either of the strength or of the wealth of society, and can take no active resolution whatever. Hamilton goes on to say, "It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments." So Hamilton is saying the courts are so weak they can't even carry out their judgments unless the president is willing to back them up, because they control neither purse nor sword and have neither force nor will. Next comes the heart of Hamilton's argument about why independent judges have the power to strike down unconstitutional laws. First, he says that that power is necessary to protect individual rights, and it's a very powerful statement of the importance of judicial independence. Hamilton says, "The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void." Why? Without this, all the reservations of particular rights or privileges would amount to nothing. So that's a powerful practical argument about the need of enforcement. There's no point of having a Bill of Rights that specifies rights that can't be abridged or having specific limits on congressional power unless someone has the power to enforce them independently to prevent one person like the president from seizing all the power. But Hamilton still hasn't told us the basis for why judges have this power, aside from the fact that it's practical and necessary to have an enforcement mechanism. And that's why the next passage is so crucially important. Why should a judge have the power when faced with a clash between an ordinary law represented by a statute and the fundamental law represented by the Constitution to strike down the ordinary law? Well, Hamilton says there's no position which depends on clearer principles than that every act of delegated authority contrary to the tenor of the commission under which it is exercised is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. This is a remarkable statement. Did you capture all of that? He says that all acts contrary to the spirit of the delegated authority are void. The people themselves have the sovereign power. We, the people, delegate parts of our authority to different branches of government, to the president, to the legislature. We reserve the powers we don't delegate, but and we also delegate to our representatives the power to make laws in our name. But when our representatives act contrary to the spirit of the delegation, which is we're assuming the legislature is not going to violate the Constitution because that represents our supreme will, then Hamilton says judges have to prefer the master to the servant, the principal to the agent. We, the people, are the principals. Our representatives are our agents. And then Hamilton says again, and even more clearly, why judicial review is necessary to ensure that the Constitution as the supreme law is superior to ordinary laws passed by ordinary legislators. Hamilton says, a constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred. Or in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Isn't that parallelism interesting? In the previous paragraph, he talked about master, servant, principal, agent. Here he's talking about the intention of legislatures and the intention of the people. But he winds this up so beautifully by saying, nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by the fundamental laws rather than those which are not fundamental. So that is the big idea, that the Constitution represents the considered, deliberate, fundamental will of the people, whereas ordinary laws just represent the temporary and hasty passions of our representatives. Now let's pause on that very important claim. Why does the Constitution represent the will of the people more precisely or accurately than a law passed by Congress today? After all, the Constitution was proposed and ratified 200 and some odd years ago, whereas laws passed by Congress today, you would think, more accurately represent the will of the people in the here and now. Well, what Hamilton doesn't say, but was broadly accepted by the entire founding generation, it was too obvious to point out, was that the Constitution was passed by a special ratification procedure that's much harder to jump through than an ordinary law. To pass an ordinary law, you just need majorities in both houses of Congress and the signature of the president. To pass the Constitution, you have to have proposal by Congress or by a special convention and ratification by 3/4 of the state legislatures or by special conventions in 3/4 of the states. Because it's so hard to ratify a Constitution or amendments to the Constitution, people have to think hard about it. They have to deliberate. Momentary passions have to be cooled by the light of reason, and that's why we can assume that the Constitution represents the profound, fundamental, considered voice of the people more profoundly than an ordinary law. Now, our whole constitutional system turns on that, on your accepting that premise, that the Constitution does represent the profound, deliberate will of the people more accurately than that of an ordinary law. And once you accept that premise, then it's obvious that judges faced with a conflict between the supreme will represented by the Constitution and the temporary will represented by the ordinary laws has to prefer the principal to the agent. So there it is. It's clear in Federalist 78. It wasn't necessary to put the words judicial review in the Constitution, because in Hamilton's idea, the entire idea of a limited constitution, as he put it, hinges on the expectation that it will be enforced by independent judges, and that reminds us of the central importance of an independent judiciary in enforcing a limited constitution. And all this brings us to the landmark case of Marbury versus Madison, which essentially is an applied version of Federalist 78. The facts are dramatic. So what were they? All this arises from a controversy in the waning days of John Adams' presidency. John Adams has just lost the contested election of 1800. It was a close election, and it was hotly contested, and it was thrown into the House of Representatives after Jefferson and his running mate Aaron Burr finished in a tie. There were rumors about a Federalist plot to deprive Jefferson of the presidency and to install John Marshall, who was then serving as Adams' Secretary of State. Adams lost his bid for re-election. He recognized the judiciary is going to be the last stronghold of the Federalist Party. So he unexpectedly appoints Marshall as Chief Justice of the United States on January 27th, 1801. And around the same time, the lame duck Federalist Senate confirms Marshall really quickly. Marshall takes his oath as Chief Justice in February, and Congress still hasn't chosen a president, and the court is so weak and enfeebled that few newspapers even notice the event. Still, this lame duck president and Congress are working dramatically to consolidate the power of the Federalists in the judiciary before it's too late. So Congress, in the Judiciary Act of 1801, creates a series of new judicial offices to give Adams the chance to make these last-minute appointments. And it also reduces the size of the Supreme Court to deny Jefferson the chance to make appointments of his own, a very dramatic example of partisan court packing early in our history. On February 17th, the House elects Jefferson as president on the 36th ballot, incredibly dramatic cliffhanger. And on March 1st, 3 days before Jefferson's inauguration, Adams stays up late, stays up until midnight, signing new judicial commissions for these new judgeships that Congress has created. The commissions are notarized by John Marshall himself, who's still performing double duty as the lame duck Secretary of State and the Chief Justice. This obviously couldn't happen today, but it was a much smaller government then. And in the confusion of the moment, not all the commissions were delivered to their intended recipients, including one appointing William Marbury to be a Justice of the Peace for the District of Columbia. So then Jefferson's inaugurated on March 4th. The newly elected Republican Congress repeals the Judiciary Act that had created the new judgeships and changes the size of the Supreme Court to allow Jefferson to make the appointments that the Federalists had tried to deny him. Jefferson also orders his new Secretary of State, James Madison, not to deliver the commissions that Adams' appointees never received. So one of the guys who didn't get his commission, William Marbury, sues, and he wants the Supreme Court to order Madison to deliver his commission. In December 1801, Marshall asks Madison to appear in court to defend his refusal to deliver the commissions, and Jefferson reacts with partisan anger. He says the Federalists have retired into the judiciary as a stronghold. From that battery, all the works of republicanism are to be beaten down as a race. So there's a lot of partisan drama around the case, and Madison ignores Marshall's request to appear. And it seems like there's a huge showdown for the court. The legal question is technical and narrow. Did Marbury have a right to his commission? And if so, did the Supreme Court have the power to order Madison to deliver it to him? But the partisan stakes are incredibly high, and Marshall seems to be in a no-win situation, even setting aside his own role in creating the confusion that made the case possible. If he ruled for the Federalist Party and ordered the White House to deliver Marbury's commission, Jefferson and Madison would simply ignore him, and they would reveal the court to be weak and ineffective. If Marshall ruled that Marbury had no right to the commission, he'd seem to be bowing to political pressure, and his Federalist supporters would be furious. So Marshall extricated himself from this dilemma with an act of judicial jujitsu that 2 centuries later still inspires awe for its subtlety. In February 1803, Marshall hands down an opinion for a unanimous court. He rules that Marbury does indeed have a right to his commission, but the Supreme Court can't order Madison to deliver it because the federal law that authorized the court to issue orders of this kind is itself unconstitutional. So imagine the confusion among the Republicans. They can hardly object to the outcome since Marshall has given them what they wanted in the short term, no commission for Marbury. or any of the other midnight judges, but they've lost a battle in the long term, because by boldly and unequivocally asserting the power of judicial review, namely the power of federal courts to strike down unconstitutional laws, Marshall has strengthened judicial authority during the decades that he's going to continue to serve on the court in ways that his opponents at the time could hardly have imagined. As with Hamilton in Federalist 78, Marshall roots his decision in the principle of popular sovereignty, in the idea that the Constitution represents the supreme will of the people. For Marshall, it's essential to all written constitutions that, as he puts it, a law repugnant to the Constitution is void. He's echoing Hamilton here. And he also says that courts, as well as other departments, are bound by that instrument, by the Constitution. Famously, Marshall notes, it is emphatically the province and the duty of the judicial department to say what the law is, and if two laws conflict with each other, the courts have to decide on the operation of each, enforcing the Constitution as the supreme will of the people and the supreme law of the land. So Marshall avoided a confrontation with Jefferson in that case, and he and Jefferson continued their rivalry with wonderfully vivid insults. They were distant relatives, and they really suspected each other. Marshall called Jefferson the great llama of the mountain. It's not clear what that meant, but something about being a llama up at Monticello and looking down at people below him. And Jefferson accused Marshall of twistification, saying that he was so subtle in turning people's arguments against them that if Marshall asked him the time of day, he would reply, "I don't know, sir. I can't tell." Still, and this is important, the two rivals and distant cousins did respect each other's institutional authority. Jefferson invited Marshall to swear him into the presidency, and a week after the Marbury case came down, Marshall avoided an even more serious conflict with Jefferson. In the case of Stewart v. Laird, the Marshall Court upheld the Judiciary Act of 1802, which had been passed by the Republican Congress and which repealed the Midnight Judges Act, and delayed the next meeting of the Supreme Court for a year in an effort to prevent the court from ruling on its constitutionality until after it went into effect. It was an example of Marshall's principle, I'm not fond of butting up my head against a wall as in sport. He didn't like to fight battles he couldn't win, and Stewart v. Laird, the more important battle, was one where he deferred to Jefferson, keeping his powder dry and using the power of judicial review wisely and sparingly in the years ahead. With his wise stewardship of the court, Marshall converted it from the weakest and most enfeebled branch of government into a strong and fully co-equal one. He did it not only by the force of his judicial vision, but also by the force of his personality. He persuaded his colleagues to live together in the same boarding house where they would discuss cases over a hogshead of Marshall's favorite drink, which was Madeira. Once, in an unfortunate moment, the justices voted to drink Madeira only when it rained, and Marshall looked out the window and said, "Our jurisdiction is so broad, it must be raining somewhere." But more Madeira and more unanimity. And Marshall's vision of a bipartisan court uniting around unanimous narrow opinions written by the Chief Justice has been embraced by his successors as Chief Justice of the United States, from William Howard Taft to Charles Evans Hughes to our current Chief Justice, John Roberts, who views Marshall as his hero.